inception of a trial. My lords and my lady, the qualifications of our judges are no secret because they're state officers. You only need to go to the website of a Judicial Service Commission and you find the truth. My lords, my lady, when we saw this very strange averment, we took the trouble to go to the website of a Judicial Service Commission and we established that Her Ladyship Justice Wilfreda Mugambi got her LLM from Birmingham University in the UK. How then do we want to bring these lies and feed them to the people of Kenya, feed them to the court, and expect that on account of such flimsy, concocted material, then the court should recuse itself? Again, is it a case of us saying, by all means necessary, we shall not appear before that court? My lords, my ladies, there are clear standards and thresholds that have been established both by the regulations governing the conduct of the court and even case law. That, my lords and my lady, first, you exercise your conscience as to what should make you recuse yourself. Number two, in the event that a party is raising a concern as to your recusal, then it must be a substantial issue. It must be a substantial question that has been brought before you. It cannot be that every frivolous allegation that is brought before the court should make the court down its tools. That, my lords and my lady, will amount or will create or facilitate an environment where forum shopping will be rife. We'll just need to mention anything, that I went to school with so-and-so, that I go to church with so-and-so, that I travel with so-and-so, and that should be a reason for them to recuse themselves. That certainly cannot be the standard. My lords and my lady, I would refer you to one of the decisions in our bundle and list of authorities. That's UNAD, Ex parte CJL 1986, 60 AL JR 528, where the court had this to say, that although it is important that justice must be seen to be done, it is equally important that judicial officers discharge their duty and do not, by acceding too readily to suggestions and appearances of bias, encourage parties to believe that by seeking the disqualification of a judge, they will have their case tried by someone thought to be more likely to decide the case in their favor. My lords, my lady, the question that we'll be asking ourselves is, what is that fundamental question that has been presented? And why this is an important concern is because sometimes such frivolous grounds are raised purely to embarrass the court. On this occasion, I have absolutely no doubt in my mind that the net effect of what these allegations have done is an attempt at embarrassing the court. My lords and my lady, we urge that you resist that invite. You resist that temptation to ask the court to recuse itself on the basis of such flimsy, baseless allegations. Just to further speak to the fact that this is an attempt at embarrassing, if not intimidating, the court, our friends for the applicant have also indicated that they have simultaneously sent or lodged a complaint with the Judicial Service Commission. Following from the submissions that I made reference to in the ruling about intimidating the court with radical surgery, again going to the question of presenting this application for recusal after the one yesterday, and now going to lodge a complaint to the Judicial Service Commission, is that not an attempt at intimidating the court? My lords and my lady, I would not ask for an answer. That is an issue that anybody, any reasonable person out there would be able to make an indication or a determination about in their own space. My lords and my lady, is it also possible that this could be one of those issues that the applicants, or rather the respondents, have complained of, as being a delaying tactic, because we raised concerns yesterday. We are raising them again today. We have spent a whole afternoon arguing about issues that on the one hand had been completely determined by this court. The second part of those issues are issues that did not have any grounding, any material or in support whatsoever. Are those not meant to delay these proceedings by any means necessary? Having taken cognizance of the fact that we came to you, both parties, under certificate of urgency, these matters must be treated with the urgency with which we came. And so we ask, my lords and my lady, that you dismiss that application with the contempt it deserves. May I now invite my learned friend, Mr. Nyamodi, to speak to a few of the remaining issues.
My lord. My lords, my lady, I wish to commence my submissions in opposition to the application for recusal before you this evening by tendering an unreserved apology on behalf of the members of the bar who have been urging and opposing the application before you today. Despite my relatively few years at the bar, I appreciate that prosecuting an application for recusal, and I have some experience in prosecuting applications for recusal, and it will become apparent in a moment, are not easy applications to prosecute. But the reason that I offer the unreserved apology is that it is my humble and respectful position that however difficult they are, there is no need for them to be prosecuted in as bad-natured a manner as these applications have been prosecuted before you. And for that, I am sorry. The only mistake that your lordships and my lady have made is to serve your nation as judges of the High Court and choose to sit in this matter. We have been told that there is no difference between this matter and any other matter, and I affirm that there is no difference. It is a matter just like any other matter. I wish to start by perhaps completing a submission that was made and not completed by my learned colleague Mr. Gumbo, who submitted a few moments before. The issue of your recusal was not just an issue in the grounds in the notice of motion that you determined yesterday, but it was contained in prayer 5 in that notice of motion. And I do not understand why the petitioners complain of bias or any improper treatment by this court. Because again, in my few years at the bar, in my relatively few years at the bar, seldom have I come across an application dated today, heard on the same day, and a substantive ruling running to in excess of 40 pages delivered the next day. So that issue has been dealt with conclusively by the court in yesterday's ruling. I wish to then focus on the authority that was cited in the dairy matter. And again, in my relatively few years at the bar, I have had the privilege of arguing several matters in the Supreme Court. Many of them are precedent-setting. Dairy is one of them, and I did not know dairy would be one of them. But the ruling of the Supreme Court delivered in the dairy matter on the 11th of October this year has confounded me for a few reasons. I am still trying to understand what the meaning of that decision is, and I will share with your lordships some of my, some of the issues I have with that decision, and hopefully in your ruling you will help me understand them. The decision in dairy is not available as an authority for what the petitioners cite it to be. And one of the issues that confound me with that dairy decision, and if my lords, my lady, when you retire to consider your ruling in this matter, you take a moment and find the original script or the original version, not the one reported in KLR, but the one that is on the Supreme Court's website and was circulated to us on the 11th of this month, you will find that at the beginning of that ruling, Paul Nyamodi, yours truly, is referred to as senior counsel. Now, I cannot insist that I'm senior counsel because the Supreme Court referred to me as senior counsel in that ruling. That is the first issue that confounded me with that ruling. The second issue is that there was no application for the learned judges of the Supreme Court to recuse themselves. There being no application for the learned judges of the Supreme Court to recuse themselves, learned judges of the Supreme Court did not then have the benefit of argument from counsel for either of the parties as to whether or not they should recuse themselves or not. And if you look at that very decision, you will not find anywhere.
Perhaps you are disparaging the Supreme Court.
I'm not. I'm speaking about their decision. If you look at that decision, in the disposition at the end of that decision, the Supreme Court does not declare that it has recused itself. So if you were to extract the order, the issue of recusal would be absent. So in respect of that, I wish to submit that the issue of recusal in the Dari matter is then obiter. Having not been an issue before court, and having not been an issue that parties submitted to, it then cannot become an authority. It cannot then be cited as an authority for recusal. The second issue about the Dari decision, and the second reason why I say that Dari is distinguishable, is as follows. Unlike in this matter, where the issues, where the facts upon which the application for recusal are based have been judicially considered and a decision given, and that decision is contained between paragraph 74 and paragraph 96 in the decision you delivered in this matter yesterday. In Dari, the issues that the Supreme Court then suo moto relied on to recuse themselves had not received any judicial consideration. Yes, those facts went on to become a complaint before the Judicial Service Commission. In the same way, the facts that form the basis of your determination between paragraph 74 and 94 of your decision have gone on to the Judicial Service Commission as a complaint. But those facts now forming your decision, the proper thing to do is not to complain to the JSC but to appeal. That is the proper thing to do. So to then file a complaint before the JSC and then reach for Dari out of context is wrong. And for those reasons, that Dari decision is distinguishable. And I urge you to distinguish it. The second decision that I wish to urge you to distinguish is the decision that was cited by my good and learned friend Mr. Tom Macharia, the Navin Premji Kerry versus Virunga Limited decision. And the reason I want to urge you to distinguish that decision is as follows. A true reading of paragraph 5 and paragraph 6 of that decision show that the arbitration commenced on the 31st of March 2021. The traditional wedding which the judge then took offense to took place on the 18th of February 2022. So it is clear, and that is clear from a reasonable process of deduction, that the traditional wedding then took place during the currency of the arbitration. That is not the case here. The screen grab that has been produced of Mr. Justice Mrima and the Speaker of the Senate, if we are to believe that it is true, is dated the 9th of October 2021, more than 3 years ago. So this decision is distinguishable on the facts. Judges do not live in glorious isolation. Your appointment as a judge does not mean that you cannot invite your friends to a wedding. On the 9th of October 2021, Mr. Justice Mrima did not know that he would have to go through the torment of sitting on this bench. In respect of the Manchester Outfitters decision, I also submit that that decision is distinguishable for the following reason. Mr. Justice Laka had been an advocate for one of the parties. Again, in an advocate-client relationship, the client pays the advocate fees. And that relationship is not at play here. And for those reasons, I urge you to distinguish that decision. My Lord, there are two pieces or two annexures that we wish to make a specific submission on, and that annexure is the screen grab from Amason Kingi's account and the prophecy by learned senior counsel Ahmed Nasir as to what would take or what is going to happen in this matter. My Lord, those are electronic evidence. And those are electronic evidence I submit within the meaning of Section 106B of the Evidence Act. In the absence of a certificate required by Section 106B of the Evidence Act, that evidence is not admissible. My Lords, it has been submitted by those who have submitted before me in opposition of the application that the petitioners are guilty of forum shopping. I wish to persuade you whilst on my feet this evening that this application is a further attempt at forum shopping. My Lords, my Lady, you will not, because you are seized with petition number 522 of 2024, that on the eve of the impeachment hearing, the petitioners insisted at an hour not too different from this that you hear their application for conservatory orders. The application was heard, and you, with exceptional dispatch, delivered the ruling the next morning at 8:30 in the morning. My Lords, my Ladies, after the ruling, the learned counsel who were in court for the petitioners engaged you in a lengthy submission, which appears to be their stock in trade, on a request for leave to amend that petition. And the requirement or the request that they wanted, or the reason why they wanted leave, was they envisaged that perhaps after the impeachment proceedings in the Senate, there may have been need to have recourse to court and seek certain orders. But what did the petitioner do? The petitioner, and we are told that he was unwell, as he was unwell, issued instructions for this petition to be filed, for petition 565 to be filed, and conveniently this petition did not come to this bench. This petition went before another court, and surprise, surprise, before that court they got their orders. And it is those orders that they seek to defend here today. A request for you to recuse yourself is in furtherance of their attempt to forum shop. And my Lords, my Ladies, as I take my seat, I urge you to bear in mind the finding that you have already made about these petitioners. Paragraph 98 of your decision and paragraph 99 of your decision rendered this morning, or rendered yesterday, which with your permission, I ask to read. Counsel also insinuated that this bench is part of a conspiracy to violate the petitioner's rights to a fair hearing under Article 50 of the Constitution. These submissions are without foundation and wholly without merit. The court has not issued any rulings or directions that would suggest such an intent. It is apparent that this argument was made for the gallery, and we find it unnecessary to address it further. This is in furtherance of that disposition of the petitioners. This is a serious matter. As has been submitted by my learned colleagues, you have a duty to sit, and we urge you to sit and dispense justice in this matter. I'm most obliged.
My Lady and my Lords,
hot on the heels of submissions by Mr. Nyamodi, now Senior Counsel, I wish to state as follows. My lady and my lords, the serpentine and sinuous submissions by Ndegwa and by my learned friend, Senior Counsel John Aminwa, just in case he says I was breastfeeding, must be faulted for two reasons, my lord. My lord, one, Mr. Aminwa refers to the Richard Nixon impeachment as the first impeachment, when it is clear, my lord, that in the US, the first impeachment was that of President Andrew Johnson in 1868, coming after he dismissed a war general, Mr. Stanton. The Richard Nixon impeachment was the second impeachment coming in 1974, because you said that was the first impeachment, and Nixon resigned. It's just important for context, my lord. Yes, my lord, it's just important for context that in the second impeachment of Richard Nixon, he resigned on the 8th of August, 1974, and thereafter the next president, Ford, took over for the next 3 years. I think it is instructed, my lord, to refer to this impeachment because of the case of...
Nixon was never impeached.
He resigned, I've said he resigned. After the Watergate scandal, the impeachment commenced and he resigned. And that is what gentlemen do when an impeachment is imminent. My lord, I want to connect this to my submissions that we shall be relying on the political question doctrine and the finality of impeachments by Senate in a comparative context. My lord, let me submit that in Gladys Boschole versus JSC, this court set out a threshold for recusal. And the threshold is, my lords, that a recusal application must be made in good faith. And if the court listens to the histrionic from the petitioners, the courts will note that the application is not made in good faith. It is tied to an intention to extend ex parte orders that advantage the petitioners. The petitioners are intent, my lords and my lady, on scuttling the bench and scaring them away from sitting so that they can have open-ended and irregular orders issued in Gachagua'S by Justice Richard Longo. Then they went to the second act of actually filing a complaint with the Judicial Service Commission submitted to Isaac Wamasa and duly acknowledged, so that this court can be scared away and run away. My lord, then the scheme is not complete. My lord, Judge Ibrahim, at page 31 of the Gladys Boschole decision, stated, my lord, that the threshold for impeachments cannot, for recusal cannot be so low, and every allegation made of any form of bias must be proved through credible evidence. My lord, I dive straight to section 11 of the Oaths and Statutory Declarations Act. The petitioner's affidavit. The petitioner made a false affidavit through a document who swore to factual issues that the petitioners then attempted to withdraw in court. My lord, that not only invites a criminal sanction under section 11, but what is more important, my lord, is that false affidavits are no affidavits and must be struck off. Because the penultimate paragraph in an affidavit, my lord, swears to the truthfulness of the whole document. Where therefore, my lords, any part of that document is false, the affidavit must be struck off. we further submit that to both applications, my Lord, that are before you, parties having been unable to meet a threshold that would warrant the disqualification of all the judges sitting in this bench, that the applications must fail. I have no doubt, my lords, that we have cited relevant authority. We have cited the authority in Jackson, Molali, and others, a court of appeal decision on the threshold that learned friend Senior Counsel Hamina wants to lower. He invites the court that at every mention of the possibility of bias, that the court downs its rules. My Lord, if that were the case, no judicial proceeding would be conducted in this country. And learned friend, Senior Counsel Professor Gideon, I told you of the number of students that he has taught. I think I've taught more young counsel in this room. And it would be impossible, my Lord, if association by way of sharing a classroom or teaching were a threshold or a test for bias, that judges would accuse themselves, my Lord. No judge, my Lord, would sit on any bench to hear any case, because we are all extracted from the same academic background and a daily trend. Unless my Lion friends are saying that. Yes, my Lord, in response to the suggestion that the Honorable Justice Mrima attended a wedding of the Speaker of the Senate, my Lord, the Speaker attended the wedding of the Honorable Justice. My Lord, the Honorable Justice Kingi, Amason Kingi, is a peripheral party in the proceedings. Indeed, if you look at the proceedings, my Lord, what we have in the proceedings is not Amason Kingi as a party in his name. It is the office of the Speaker as a corporate office who is a defendant or a respondent in these matters. But number two, my lords, the Honorable Speaker Kingi merely presided over the proceedings in Senate and was not a voting member in the sitting of Senate that led to the impeachment of the former Deputy President. My Lord, the Honorable Kingi has not taken part in the appointment of this bench in any form. My Lord, clearly the petitioners are clutching on straws, and every attempt at ensuring that this court does not proceed seems to be falling by the wayside. I urge the court and I invite the court to consider this application for recusal as another attempt to frustrate the processes of this court and to ensure, my Lord, that this bench does not proceed to dispense justice that ought to be dispensed expeditiously in line with the Constitution. I pray, my Lord. And my Lord, on the appointments of judges, my Lord, clearly, if peradventure the argument on conflict extended to who appoints, my Lord, the President appoints all judges, and is a party. I think they should have added that ground, perhaps, because the President appoints all judges. But that cannot be a cause for a party seeking a recusal, my Lord, because the President, in performing a constitutional mandate, just like, my Lord, the CS Environment Soipantria exercised her statutory mandate in appointing Florence as a board member, my Lord, cannot be a cause or a basis for seeking or asking for consent. My Lord, soon parties will then apply for recusal on the basis, my Lord, that to deputy judges or litigant and a judge belong to the same community. Thank you, my lord.
Sorry, none of them is quite near me, so I think I will. Thank you. Thank you very much. Just a brief rejoinder to the application, and especially in view of what has actually been disclosed after the arguments. And my lady and my lords, I would be urging you kindly to actually go through these voluminous decisions we have given to you, because part of what some parties are submitting and saying it falls on all fours in relation to the matter before you is nothing far from the truth. And the example that has been cited is that of Rai and Virunga Limited, where it has actually been shown that that authority cited does not in any way relate to what is before you in terms of facts and the applicable law. It has been clearly demonstrated that here disclosure was necessary because...
Just a minute. We wish to adjourn for 10 minutes. You can take health break for 10 minutes.
Will you say something? Yeah, I will say something. You want to be last? No, I should be last.
You should be the last because in the SG.
The SG. Yes, I will want to say something. And you say it's political. It's political. Political. But with interest. This one is meant to derail. How long have you taken? A few minutes. I don't know. But I yeah, 1 minute.
He overcome the lines the devil had put for him.
Alishinda mipaka ambayo shetani alikuwa amemwekea.
He entered the next level.
Aliingia kwenye hatua nyingine.
Today, I prophesy. Just like Job. Just like Job. God bless his life.